SJC-13142, Graycor Construction, Inc., v. Podium Developer, LLC, and others.
Okay.
Good morning.
Attorney Dockery, yep.
May it please the court, Alex Dockery on behalf of Podium Developer LLC, Podium Owner LP, and Office Tower Owner LP. With me here is Peter Billows and Martin Fantazzi as well. The question before us today is whether this court's COVID orders, issued pursuant to its general superintendent's authority, operated to toll the statutory period for filing a notice of contract with the Registry of Deeds pursuant to General Laws, Chapter 254, Section 2. As this court has recognized as recently as last year in Committee for Public Counsel Services versus Chief Justice of the Trial Court, this superintendent's authority, while broad, is not unlimited and does not permit the court to usurp or co-opt the functions of the other branches of government. The Superior Court erred in failing to analyze whether application of the COVID orders to the Registry of Deeds to toll the deadline set forth in Section 2 of the Mechanics Lien Law constituted an exercise of power intimately connected with and necessary to the exercise of strictly judicial powers.
Well, now, counsel, that point that the opposing counsel is making, that maybe our other statutory extensions or tolling of statutes are fine because it affects court cases and we have superintendents over the inferior courts, but we don't have superintendency over the Registry of Deeds, correct?
That is correct, Your Honor.
So what do you say to that argument that we can't do this because of that?
Well, in fact, Your Honor, that is exactly what we are saying. We are saying
That is what you're saying.
Exactly.
Okay, I got my parties mixed up.
No
Never mind.
That's exactly what we're
How
saying.
about the intertwining?
Yeah.
How about that it's so intertwined with what we do and our superintendents of the courts that we can't separate it out?
Right.
Well, the fact of the matter is that the Superior Court did not engage in any of that analysis to determine the relationship between the statute at issue
But
and the superintendent's authority.
that's not really a factual issue, right? It's a legal issue, whether these different legal provisions are so interconnected that it invokes our superintendent's power.
That's correct. But the Registry of Deeds is not a court of inferior jurisdiction.
Well, I get that part. I'm just trying to understand whether what the Registry of Deeds does, which is very limited, is sort of a critical first step, and meaning that they are intertwined. I don't know the answer. I find it confusing, but help me out here on why.
Counsel, let me back up on Justice Kafka's question then. Ultimately, what happens if they perfect their lien and they don't get paid? Where do they go?
If they perfect the lien,
And they don't get paid, where do they go?
ultimately they will file an action in the
Right.
Superior Court, which then has to be recorded in the Registry of Deeds.
Right, but they're going to come to us.
Ultimately, yes,
Right.
but first, they have to have created the right to perfect the mechanics lien. What's at issue here is Section 2. A mechanics lien does not exist unless a notice of contract that complies with the statute has been recorded in the Registry of Deeds.
Sure, I
There-
was getting more to the point you first made, was whether or not our authority would extend to tolling these types of provisions, because ultimately, this is irrespective of whether the Registry of Deeds is under our jurisdiction, ultimately, it comes here in order to perfect whatever rights they have under the mechanics lien statute. So wouldn't that be intertwined in what we do, such that our orders should have these kinds of effects to these kinds of statutes, just like we did with statutes of limitations?
No, Your Honor. You have to look at each piece of the mechanics lien statute to determine whether or not the superintendent's authority would apply, and then should you find a nexus between the statute at issue. I think Your Honor is referencing Section 11, where you have to commence an action in the Superior Court and then record that subsequently in the Registry of Deeds. That analysis would be a closer analysis, and the first part would be different, but the result is ultimately the same. Because when you find that there is a nexus, then you have to analyze whether or not the power being exercised by this court impermissibly supersedes a statute. And when we examine the purpose of the Registry of Deeds, which is to provide an accurate, up-to-the-minute recording of the status of the encumbrances on real property, then we cannot permit a tolling of that to create unreliability in the land records. And so, where it would be a
But,
closer question.
Counsel, the statute of limitations is set by the legislature. Is your position then that our COVID orders cannot toll those as well?
No, Your Honor. The statutes of limitations are inherently related to this court's superintendent's authority of causes of action, maintenance of actions, and the administration of justice. Here, what is at issue is the very deadline to create the right to have a security interest on real property. And so if a claimant does not record a notice of contract in the Registry of Deeds, there is no claim to perfect by filing a statement of account and enforce by commencing an action in the civil courts. And so,
Would you say that we can't do anything under superintendents about when the notice of contract has to be filed? That's your position.
That's correct.
I understand. Could we have said, but you don't have 90 days, you have 120 days to file in the Superior Court?
no, and the reason for that relates to the second piece of the analysis, which is that the inherent reliability of the land records, this court has repeatedly recognized the importance of accuracy in the Registry of Deeds. And in order to extend the deadline to commence, let me back up, Justice Lowy. You could extend the deadline to commence the action here in the court. What you could not do was then further extend the deadline to record that action in the Registry of Deeds after you had commenced it. And so it's that nexus first between the superintendent's authority, but then there's that second essential piece of the analysis if you find the nexus, which is, would the exercise of this power impermissibly supersede the statute? And here, the Superior Court did not perform either of those analyses in its ruling, and for that reason, it created error.
Counsel,
What do you actually have to do, I'm sorry,
No, go ahead.
to record the lien? What's the physical steps that you have to take to do that?
So you have to record what's called the notice of contract. It names the real property where you performed, the contracting parties, the amount of the contract, and then that is taken to the Registry of Deeds in the county where the work was performed, and it's recorded on the land records. And in fact, Graycor here did record a notice of contract in April of 2020 during the pendency of these orders. The Registry of Deeds, importantly, was not closed for recording.
Well, that's where I was going. What if the Registry of Deeds was closed during the emergency, the period of time when there was, people couldn't do anything? What if the registry had been closed for several weeks?
If the registry had been closed, we would have to have examined what other steps the Register of Deeds, who's in charge of the registries, had taken in order to address that issue. The fact of the matter is here, where the registry is closed, individuals searching title on the land records would have been on notice that perhaps there was an unreliability with respect to the status of those land records. But here, the registry remained open, documents were recorded, transfers occurred, people were able to buy and sell property, and for that reason, it is paramount that the accuracy of the land records be preserved.
But some of them were closed, right? Some of them were closed, right? Some of the registries were closed. So are we going to have a rule that's going to work where if one registry closed during COVID, you're out of luck, and if they were open, you may be fine? I'm just trying to get a sense of how that's going to work.
Your Honor's question actually gets to the very central issue here, which is the Registry of Deeds is its own department, and it governs itself. And so each county's Register of Deeds is in charge of what goes on in that registry.
But again, they're the first step in a process. They can't do what we did, right? Can they? There's a statute out there. Could they have done this themselves and issued a COVID suspension of that statute?
That would have been the purview of the legislature, Your Honor.
Well, so then we kind of we're in a box, aren't we? if if only the legislature could do it, obviously that can't be the case because we can do it, right? But the registry can't. So the registry can shut down this process, this ability to basically hold up title for a mechanics lien. But they can't do anything about it. I'm confused by that. We can fix it, but they can't during COVID. And don't they think we're fixing it for them?
No, Your Honor, there's nothing in the record to indicate that the registries believe that the SJC's orders are fixing any sort of issue for them. And I also don't believe it's accurate to say that the registries were closed for the recording of documents. While they may have been physically closed, I believe all of the registries had electronic recording available here.
But I understand the equities aren't so drastic in this because there's another way. This is only this sort of process where you use the mechanics lien to get title. They can still sue separately, right? So they're not completely out of luck.
Absolutely.
But your argument, if we take it to its extension, may leave a lot of people completely out of luck. Administrative processes out there and everything. So if you miss any of these administrative deadlines anywhere in the Commonwealth, I'm just trying to understand, you're out of luck. Is that right, or am I wrong?
No, Your Honor, the analysis would have to be done for each statute that governs the administrative process that.
Saying we can't mess with the executive branch. We can't toll any of their time deadlines. That's not our power, even if it's interwoven with one of our statutes and our powers.
No, not at all. What our argument is that the analysis has to be done in each instance. First, whether the power that is to be exercised is inherently connected with and necessary to the exercise of strictly judicial powers. And if so, then the separate analysis is whether the action that is to be taken is going to impermissibly supersede a general law.
I understand that in the abstract. That's a nice distinction. But in reality, right, isn't this pretty tight? That deadline in the Registry of Deeds is connected to 2 other court deadlines, right, or 3 other court deadlines, right?
No.
It's not. If you miss the first one, you can't do anything, right?
That's correct, but it's not a court deadline. The security interest is created by the initial filing of the Section 2 Notice of Contract.
No, but if you miss the registry deadline,
Yes.
that court process is short-circuited completely. You can't do that process, right?
There is no claim to enforce in the court.
Exactly. So missing that deadline puts you out of luck. Now, let's do some there are a lot of other statutes that have an administrative exhaustion requirement. I don't know if they have time deadlines in them. I assume a bunch of them will. But if your analysis is correct and we can't do anything about it, are all those things going to be dead too? Because again, it's an interconnected statutory deadline.
No, Your Honor. This deadline, specifically related to the mechanics lien, is unique in nature because what it does is create a security interest. And because it is a creature of statute, we require strict compliance. Okay. What a mechanics lien does is it creates a right to encumber the real property of another as security for a breach of contract claim. And in fact, what has occurred here and what often occurs is it's the right to encumber the real property of a party with whom you may not even be in contractual privity. So my clients are not actually in contractual privity with the claimant in this case. And so you cannot apply a broad conclusion when what is at issue here is solely the deadline to file and record a notice of contract pursuant to Section 2 in the Registry of Deeds.
Counsel, do you know if we have any superintendents of power to remove the registrars of deeds?
Only with respect to the land court.
So we can only remove the registrar in the land court?
Yes, Your Honor.
How do the other registrars, are they elected in all the counties?
They are. They're elected officials.
And so removal would be by how could they get removed if they did anything wrong?
I believe it would be impeachment, but I'm not certain.
All right.
Having failed to determine whether the Registry of Deeds constitutes a court of inferior jurisdiction, and whether the tolling of the deadline set forth in Section 2 was an exercise of power intimately connected with and necessary to the exercise of strictly judicial power, and further, having wholly avoided any analysis as to how such tolling would impact the essential functions of the Registry of Deeds and the land records, the Superior Court erred and must be reversed. Thank you.
Okay, thank you. Okay, Attorney Costello.
May it please the court, Christopher Costello on behalf of the appellee Graycor Construction, Inc. Your Honors, appellee contends that the lower court was correct in its analysis and that this court has the authority under its inherent authority as well as its superintendent's authority under GL Chapter 211, Section 3.
Let's talk about that for a minute, because your opposing counsel here has pointed out that we really have very limited authority with regard to the Registry of Deeds, and that it's in fact all handled through an executive function, and that this is a unique thing because it creates a security interest. Why is that? Why is she incorrect in that analysis?
Well, I think going back to Justice George's question, the GL Chapter 254 in the whole establishes the connection to the court system because it is the first step, but the first step means nothing unless you follow the steps. And under Section 5, you have to bring an action in the Superior Court or the District Court in the district where the land lies. Then you have to proceed under Section 11 to enforce your claim against the property, or under Section 14 to enforce it against a bond that's filed to dissolve that lien. And the court is involved in issuing orders for foreclosure under Section 18 if you get that far. And we're here today because the appellants brought a verified complaint under Section 15A to dissolve the lien in the court. So the courts are intimately connected with this whole process, such that the superintendent's authority and the inherent authority of this court has to lie. And furthermore, with extent to the...
Counsel, aren't you skipping a step there? I mean, so the Section 2 in and of itself creates a right, right?
Yes.
And that creation is notice to the world that now I have a lien on this specific property. That could be in and of itself valuable without the courts. That is, the courts are not intimately involved in that. It's only when you go to seek to enforce the mechanics lien, which then I think your opposing counsel was correctly conceded. At that point, our superintendent's powers would extend to that because you now need to file something with the court. But the nexus between the recording and the court seems to me quite attenuated. What Section 2 is notice to the world that I've got a lien against this property. So if you're going to buy this property, you better clear that lien first.
Well, Your Honor, I would say that while the lien is established under Section 2 and provides notice to the world, the person searching title know that that action in and of itself, or even in combination with the recording of a statement of account, only have that lien in place for 210 days, which is a very limited utility.
But that 210 days, I think, is something that we might be able to extend under the COVID orders, right?
So, is Your Honor, if I'm understanding the question correctly, you're understanding that you would only extend the time period to subsequently file an action and record it?
Right. At that point, it touches the court.
Well, if that were the case, Your Honor, then I would suggest that one of the primary goals of the mechanics lien statute that the appellants focus on, and that is when a person goes in to review title and can be confident that after a certain period of time a lien has already been dissolved or its own weight, that would sort of create the relation back problem that this court has addressed to earlier. If the court's authority were limited to just extending the time period...
But how did that relation back case go? Because I didn't think that supported your side.
Well, the relation back case is fine as long as the time period has not run under the statutory deadlines. But if had the time period run, then you're barred from relating back.
Right, and okay.
So what I'm saying here, Your Honor, is if the court superintendent's power only permitted the extension of time to file the complaint, it's really what tells the world that there's an enforcement of a lien happening is when they look and see that there's a complaint that's filed and recorded in the
So we
registry
can
of
toll
deeds.
that deadline without also tolling the deadline to create the lien itself.
The lien is created under Section 2.
Yeah,
So what persons searching the title records, if they see that a lien is created, and now more than 200 days have elapsed since the creation of a lien and no complaint's been filed, that implicates the certainty argument that the appellants are making. A title examiner going in and seeing that 200 days have elapsed and no complaint's been filed would be reasonably certain that there is no more lien clouding title to this property.
well, what about somebody looking at a statute of limitations? Wouldn't they also say, oh, well, it's been 3 years? Wouldn't they have the same problem?
Well, I think as this court set forth in its COVID orders, the statute of limitations are a very different thing than deadlines under other statutes. I think all litigants are pretty well aware that the statute of limitations time period can move under the discovery rule. And there's nowhere for people where people would search to see, where the world would search to see if a cause of action should have died under its own
So
fine.
counsel, this mechanics lien creates the cause of, creates the right, correct? Creates the cause of action.
Right,
So-
there's no claim without the file.
But, so a statute of limitations, that's a different issue about but isn't this more like a statute of repose? Which is concerns about the extinguishment of the claim?
No, you're right. This court has already recognized that statutes of, that the mechanics lien statute is not a statute of repose in
I know it's
National
not, but
Lumber.
I'm just saying, also with regard to statutes of repose, I'm wondering how those would operate under the COVID rules. Would they be in the same category as your mechanics lien because a statute of repose does a little bit more than, it creates a right, doesn't it? Isn't that, we're looking more at when the right is created, not when the lawsuit is filed. Like the right gets extinguished after a certain period of time. It's the right, not just the right, the timing of the filing.
I think that the deadlines imposed by a statute of repose have been examined very differently by this court, and they've been imposed very certain in the Stearns case a year or two ago. I think overall that in the context of the COVID pandemic, as this court said in presenting its orders, that you have authority, not only inherent authority, but authority under your superintendent's power. This is a very different circumstance, and the survival of mechanics liens and the ability of contractors to meet with counsel, conduct a title search, and get the liens filed is sort of the same considerations that this court looked at in the Shaw versus Melendez case, and looking at, what's the effect of the pandemic on the ability of clients and counsel to initiate a claim.
But that's all in court, though. I mean, here we've got this weird process, and it is separate, because like you can vindicate your rights without going through it. You can bring a lawsuit and sue for this damage separate and apart from clouding title, right? That's the norm. I mean, I understand there are two ways for you to get reimbursed. There's the mucking about in the registries and putting cloud on title. And then there's another way, right? You can go around it and go to court, and this doesn't impact that at all, does it?
It does not, Your Honor, but I would submit that in the context of the pandemic, and particularly to our case, as counsel mentioned, Graycor was not a direct contractual party with the podium entities. There was the specific entity in between that we contracted with that's since filed for bankruptcy. So because of the COVID pandemic, we've sort of been left without a remedy other than the enforcement of the mechanics lien, as have the sort of down the chain subcontractors.
So, but the pandemic is not the reason that you couldn't figure out who the notice of contract was supposed to be.
So, Your Honor, Graycor did attempt to file a notice of contract earlier on without the benefit of counsel, without the benefit of a title search, and from a distance. It was only once counsel was retained and we were able to perform a title search that we were able to uncouple sort of the Byzantine filings to determine that the property where the work was performed.
That's a choice of whether to hire counsel or not. That has nothing to do with the pandemic, which is not, you may disagree, and if you do, please tell me, but that's not an irrelevant point, because we're dealing with the notice of contract, something that really doesn't touch the court system.
Well, 2 points, Your Honor. In the Shaw versus Melendez case, the court was focused on the ability of would-be litigants and their counsel to initiate a claim. Graycor tried to do that on its own with respect to the COVID restrictions in effect that affected its business and affected everyone.
Don't we have, if we adopt your view, aren't we really running into some constitutional separation of powers? Because I don't know why this is different than us taking every administrative, I'm thinking of Medicaid or all these other areas out there where there are time deadlines for doing things. Do we have the ability to, change all those deadlines too? It seems like, I don't understand how we can play here without changing all of the sort of executive branch rules.
So I think this is where the nexus argument, where we fundamentally disagree, comes into play. That we agree that there needs to be a nexus to judicial administration. We just think that there is one in this case.
But I think you say every time deadline that's impacted in the executive branch, we can fiddle with if it ends up dealing with a court case. Is that right? Every single one of them? Because, I can't think of them off the top of my head, but I'm just thinking of, you've got a lot of administrative time deadlines out there. Did we have the ability to suspend all of those through our COVID orders?
I think because this court distinguished between the tolling put in effect for statute of limitations, which was very broad, versus the tolling that you applied in terms of deadlines under the statutes, which is very narrow. It's only deadlines falling within that narrow period that I think the court exercised its authority in a way that was so narrowly focused and consistent with its inherent authority that you can do that to the extent that there's an involvement of the judiciary.
You're saying because the statute expressly contained a deadline for the registry, that's different than if the administrative agencies had created them through regulations or other things? And we could, because we mess with the statute of limitations in our COVID orders, we could do that. We couldn't do it if it were done through a regulation. I'm not sure I follow.
I think it goes back to appellant's nexus argument. I think it has to have a nexus to the administration of justice, and I think we have that here because of how 254 is laid out, requiring court action to do anything effective in terms of enforcement or foreclosure or even dissolution.
But everything, we don't enforce through, everything is enforced through the courts. So there's got to be some limitation on that rule, right? Just because the ultimate resolution of the issue will be in court can't be enough for us, right? It has to have some narrower restriction than that.
No, and I think that the separation of powers issue is what imposes the restriction. And in this case, we would submit that there's no separation of powers issue because the registrar's job, as appellates point out under the statute, is to record. You present the registrar with a notice of contract or a document and a check.
But we don't have any say over how they do that.
That's exactly my point, Your Honor. Your order does not tell the registrar, the individual registers, to record or not record this notice of contract. There's nothing in a notice of contract that sets forth the date the work was last performed on a project so that they could even go about making a determination of whether the time period has lapsed. That they record the notice of contract as long as the property description matches what they have in the registry documents. It's up for the courts to determine under the statute whether or not, looking at the time, whether the filing was timely or whether the claim should be dissolved or whether it should be enforced.
And if we do that, we're not superseding a statute? If we do that, we're not superseding a statute?
No, Your Honor, because if the mechanics lien statute, it has two purposes. Appellants focus on the recording and the certainty of the recording statute, but the other purpose of the statute is to protect contractors who provided valuable services to improve real property. So we submit, in this case, the application of the COVID tolling orders to our circumstances in this case is consistent with the legislative purpose for the mechanics lien. It does not impact the certainty argument that appellants make, because in reality, a person searching the statute for these properties at 60 and 80 Causeway Street would see a notice of contract filed for the first time on September 9th, and the complaint to enforce that on September 17th. So this isn't a circumstance where someone will go in, see that a notice of contract had been filed, and assume that a lien had dissolved under its own weight through an action. If there are no other questions, Your Honors, we rest on our brief, as well as the lower court's ruling, which we believe supports our arguments, and we request that the court answer the reported question in the affirmative. Thank you.
Thank you.